believe that you are in the beauty industry because you all are awful quiet. Good morning. Welcome, welcome. For how many of you is this your first premier Anaheim show? Raise your hands. All right. How many of you are licensed nail professionals, licensed manicurists here in the state of California? I'm going to raise my hand because I'm going to. Right, you'll notice that this show does not have a huge presence of nail manufacturers, but I don't want you to be disappointed. And that's because you're getting the experience of being here in this classroom and interacting with people you would not have had access to had you not made the effort to be here today. So thank you so much for being here, coming out first thing in the morning. I happen to sleep in, which is not like me, but mornings are my thing typically. But months and months and months ago, long before we had something good to talk about, we had this class pitched to the show. And credit to Premier Anaheim for taking on this topic because it's not sexy. There's no glitter in this class. No rhinestones. Nothing sparkly, except the people that are seated next to me because they're kind of shiny. But this class was titled Booth Rent Isn't Legal, Nobody Told Me, because at this very moment that's the case. So we will be talking about that, but because we do have some good news to share, we will be going beyond that to talk about strategy and next steps and what we can do collectively as an industry to remedy this situation for licensed manicurists now in the state of California. So this class is presented by Loopholes and Lawsuits, and you might recognize our faces from our videos. And Mike, do you want to read the disclaimer?
Sure, let me just read it so it's on the record here.
Okay.
So it's the one we give on all our episodes. The information and advice provided is not intended to be taken as and should not be construed as legal advice. No attorney-client relationship is formed through any interaction with Loopholes and Lawsuits or any discussions on our podcast. You must consult with your own private attorney for issues that are specific to your situation. Further, all topics of discussion are based on the law in effect at the time of taping. Please make sure to check for later podcasts of Loopholes and Lawsuits for any changes to the law.
Sounds like an attorney, doesn't he? Yeah. That's because he is an attorney who happens to be unique in that he has a background in our industry. Mike, could you explain a little further?
Sure. So just a short bio about myself. 23-year attorney. I have my own office here in Huntington Beach, California. I have a lot of exposure in the beauty industry, in particular the nail industry. Grew up in it. Parents had multiple salons, manufacturing, and then after they retired, a lot of our business competitors became my business law clients. I'm a co-founder and board member of the Pro Nails Association. In my own private practice, I represent a lot of salon owners, licensed professionals, manufacturers, distributors on various issues. With respect to the folks sitting in this room right now, issues that I deal with in the beauty industry, the nail industry in particular, is employment and wage and hour. And so when these issues of independent contractor versus employee came up several years back, many of my clients and people I know in the industry asked me, what are my thoughts, what can we do, and so on and so forth. So that kind of leads us to where we are today, and I'm hoping that I can inform you what the current state of the law is and what we can do moving forward to make some of those changes.
Excellent. I'm going to save myself for last only because I want to honor our special guests, which we didn't know we would have special guests when we first set this up.
Yes.
We just hoped that we were enough.
Yes.
But as it is, we have two special guests with us today. First is Colin Edwards. He is the District Director for Assemblyman Tree Top. If you don't know who that is, you will understand by the end of this class why that is so important. But Colin, would you introduce yourself to us?
Yes, good morning everyone. Thanks for having me, Jamie and Mike. It's a pleasure to be here. I'm the District Director for Assemblyman Tree Top, who represents Little Saigon, which is the largest population of Vietnamese folks outside of Vietnam. And the manicure nail industry is a huge passion and policy priority for him. So we'll kind of talk about our solutions in a minute, but happy to be here to support whatever you guys need to get this passed, and we'll talk a little bit about next steps going forward and how you all can help.
Excellent. Thank you for that, Colin. And then next is Myra Reddy. Myra, would you please stand up? Myra is the Government Affairs Director for the Professional Beauty Association, and she's been doing this for quite some time. In addition to what she does nationally, and you don't get to sit down quite yet, Myra, because I want you to say something, but she's even more connected to California with her experience with working with the legislature. So we hold a special place in her heart.
Well, I used to live in California, and I used to work for California Assembly many years ago. But I've been with PDA for about 15 years, but my entire background is working for elected officials before I came on board with the association. Professional Beauty Association does work closely with the state of California. In fact, it's the only state where we retain full-time lobbyists. Fun fact. Just to monitor and track, because there are a lot of labor and wage changes that happen in California, and it's very unique to California. It doesn't tend to happen anywhere else nationally in other states that we track information for. So super excited for all of you to be here. That's so amazing to see that you're all future advocates. Thank you so much.
Oh, and give a plug for your class tomorrow.
Oh yes, I have a class tomorrow where we will touch on a little bit about this, and then about more California law changes, labor and wage, as well as some national issues that we're seeing being picked up in other states, just to make it well-rounded. And we're going to talk about the interstate compact on cosmetology, as well as some federal tax credits. So that's at 10 a.m. Actually,
It's at 2:30.
oh, sorry.
2:30 tomorrow.
Gosh, I don't know my classes.
That's
I
okay.
know you guys can relate to the ADD issues. 2:30, but I think it's in this classroom.
It is in this class.
So come back at 2:30.
Excellent. Thank you, Myra. All right. I'm Jamie Schrabeck. I am a licensed manicurist and establishment owner here in California. I've been licensed since 1992, which is a long time. I have, for the bulk of my career, now I can say that I had employees. I'm back to working solo again. So the impact of this situation on me personally and professionally isn't nearly as great. But this is not about us as individuals as much as it is about us collectively as an industry and what we can do to support each other. So that is why I am here. That's why I'm grateful for this support. Normally we wouldn't be in this position. Normally we'd be all scrambling around hoping that someone would do something. Well, that's you. You are here and you are going to do something because I'm going to haunt you otherwise. Find out that you were here and you walked away thinking, I don't know what to do. You will definitely know what to do by the time you leave this classroom today. So thank you again for being here. All right, so Mike, could you go over this just briefly? And for those of you who have been keeping up with us, our Loopholes and Lawsuits podcast was not intended to be an AB5 Labor Code, AB 504 focused podcast, but the timing has worked out that it has been recently. But we came up with this timeline, and you can take a screenshot of this. I've asked you not to record the class, but you can definitely take screenshots if you think that you need this. But this is how we got here. Mike, could you comment a bit about the situation?
Sure, so just a brief chronology of kind of how we got up to here. So back in 1989, there was a case by the name of Morello Sons, and in that case, the court established several criteria to determine who is independent contractor and who isn't. Okay, and then kind of fast forward in 2018, there was a California Supreme Court case called Dynamex, and it involved current delivery service. And in that case, the California Supreme Court established what's called an ABC test. Maybe you probably heard some variations of it, but it's really ABC. It is in the conjunctive. It is not one or two of the three. It is all three, okay? And what happened post-Dynamex is that the California legislature wanted to apply the ABC test across multiple industries. The ABC test at the time, in the case, applied to that particular case. But Sacramento said, hey, we want to apply it to multiple industries. So that process of codifying it into statute or regulation was through AB 5. And you've probably heard of that. There's a lot of discussions that were going on at the time. And I'm not here to advocate one side or another. I'm just telling you what the history, the historical perspective is. So once AB 5 passed, in the process of negotiating AB 5, there were different constituents who wanted certain carve-out or exemptions. And as part of that process, the beauty industry had an exemption, okay, that allowed beauty professionals, licensed beauty professionals, to maintain independent contractor with renter status, okay? And that exemption would be active for several years, and then unless renewed, the exemption would expire, at which time licensees would be viewed as employees unless there's some type of way to determine if you're independent, okay? Fast forward, okay, 2024. In 2024, the exemption did not get extended. So that meant that as of January 1st, 2025, all licensed manicurists in the state of California do not have the ability to be independent contractors / booth renters. And I'm kind of using, there's no legal definition or terminology of booth renter. It does not exist in the tax code. It does not exist in the labor code. Okay, it's independent contractor. But the way it was properly applied for licensed manicurists was that you would be a booth renter. So as in the past, 2024 and before that, you were a booth renter, right? You had a spot, you would then pay rent, you would then at the end of the year issue a 1099 form for income to the landlord or the owner of the space, right? That's how it worked. That exemption expired. So right now, everyone is considered, licensed manicurists are all considered employees. Okay, there's what's called the rebuttable presumption of the ABC test, but in my practice and in talking over this issue with multiple people, I cannot see an example of where a licensed manicurist could be an independent contractor. It just doesn't exist in practicality. A lot of people say, well, in theory. Well, yeah, that's in theory. But once we get to the practical application, it does not work, right? Because I will ask you, if you were a client, or if, let's say if I were an investigative attorney, I would ask you questions, you know, this, and this. Based upon your response, I would say, well, you may have had a contract that says you're independent. You may have had this, but the practical reality is you're not independent, you're not booth renter, okay? So that's where we are now, is that everybody is an employee. And the industry is trying to figure out, you know, what do we do? Because a lot of folks have invested monies into development of their salons. If they're an owner or if they're licensed manicurists, they don't want to be an employee. So it kind of brings up to where we are today. And we're very blessed to have Colin here next to us to kind of guide us through some of the next steps.
So, Mike, here's the ABC test on the screen.
Sure. You want to go with that?
This should be news to no one. You guys are familiar with the ABC test, and if you're not, don't hesitate to raise your hand and say, go over this, please. Does anybody want more detail? Excellent. It only takes one person to educate the whole room, so thank you for saying that. All right, so the ABC test, we talk about the ABC test, but we talk about AB5, we talk about these things. These are shorthand for what is actually the law. When you go to look up the law, it has to be in code somewhere. And because this has to do with labor, it's in the labor code. And you'll find the ABC test in Labor Code 2775, which I'm not asking you to remember that number. You don't need to remember that number. We're gonna have all sorts of links and resources for you. So if you wanna go back and look at it, don't take our word for it, but we have taken a direct quote from the Labor Code so that you can see exactly what it says if you were to look it up for yourself, which I encourage you to do. But this is the ABC test. And where it breaks down for us as we try to argue and fight for our ability to keep doing what we've been doing all this time is the fact that in the B section, where it talks about someone performing work outside the usual course of business, we cannot argue that, well, look at this particular business. This business is a salon that only does balayage. And if I go to rent a space there, I'm different from what they usually do because I'm doing nails and they're doing balayage. Well, we all know, or should know by now, that in the state of California, there is only an establishment license. There is no specific license based on the type of regulated beauty services that you offer. It is an overall umbrella license called an establishment license. And once someone holds that establishment license, they are authorized to offer any of the services that are regulated by the board. So we know that that's cosmetology services, barbering, electrology, aesthetics, nails. What's not regulated, braiding, threading, those are outside of us. We're not regulating that as part of the Board of Barbering and Cosmetology. So that being said, it only depends at that point on who is there to provide the service. So for example, I own an establishment. I can't offer barbering services unless I have a licensed barber providing the services. So that's where the establishment owner is dependent on the individuals who work within the space, whether they're working as independent contractors or as employees. That's what controls the type of services that they offer. But I think Kristy Underwood has made it clear, and Kristy Underwood, the executive officer of the Board of Barbering and Cosmetology, is here at the show today. They are downstairs, booth 401, and if you need to repeat, that's what I forgot to do was have you guys do a cheer. Sorry. Kristy will reiterate to you that there is no such thing as a nail salon license. There's no such thing as a hair salon license. It's only the licensed establishment that matters.
So because B is the part of the ABC test that independent contractors or woodworkers, can't possibly meet inside of a single establishment that could authorize all services depending on who's there, how are you making it work? Is it now the only option that you have to work solo?
Well, that's the whole discussion that we had with Kristy in one of our podcast episodes, was that you're either an employee or you are the establishment owner. If you are the establishment owner as a licensed manicurist, you can rent to all the other license types who have the exemption. But as the person who is doing the red team, as a licensed manicurist, you are prohibited from doing that at this point right now. And I would have you guys hold your questions for a little bit, because I don't want to go into too much of this right now, because we could argue, has it gone to court yet? Has anyone sued? Has anyone thought about a lawsuit? Yeah. Has anyone thought about a lawsuit? I'm going to go ahead and bring that up right now, Mike.
Has anyone here? Raise your hand if you've heard of someone who's filed a lawsuit or is contemplating a lawsuit.
She must have heard, I'm going to stop her right now, but she must have heard us talking about her in the hallway. She might have been eavesdropping on us as we were talking. This is Kristy Underwood, the executive officer of the Board of Barbering and Cosmetology. Kristy, welcome, welcome.
Thank you.
Colin Edwards here from Treetaw's office, district director.
Oh, nice. Hi.
And you know us, and you know Myra.
Of course.
Yes. So we were just talking about how the B part of the ABC test is where we are not able to meet all three. Because it's not pick and choose your own adventure. You have to meet all three. And that's, but again, we don't want to get too hung up on this, but we were just starting to launch into this idea of, well, you know, I still want to do it the old way. I want to fight this. And we all know that one way that you can fight is through litigation. And has anyone contemplated, we asked that of you, has anyone contemplated filing a lawsuit to have this law not apply to them?
Or have you heard of anyone contemplating a lawsuit?
One of my customers is a labor attorney, and we have looked into it. She just recently wrote an article about this because attorneys are dumbfounded by the lack of background, if you will, that led to just manicurists being affected. So yes, discussions into litigation are happening.
Yes, please.
Well, no, I'd like to talk to you after. I have to leave here right away, so maybe Jamie, you want to handle just some initial discussions with you?
Yeah, that's great.
I'll connect
After
afterwards.
class.
Yeah, so I don't want to take up too much time.
Excellent. But can you just explain briefly what it takes to actually be a plaintiff in a lawsuit of this type?
So to sue and get some type of maybe an injunction or a court order to halt enforcement of the law, it would require that there be a plaintiff. You've heard of that term. And that plaintiff would have to be an affected nail licensee. So just hypothetically, if if you were to call me after this session and say, hey, Mike, I'm a California licensed manicurist. I was formerly a booth renter. Now, as a result of this session, I discovered my livelihood is at stake. And this doesn't work for me to be an employee or to be an owner. I do not believe it is fair because it singles out only licensed nail manicurists, right? Then there's a possibility, after we talk further, that I said, you know what, you are a prime candidate to be a plaintiff. And what we would be asking the court is, we want equal treatment and equal protection of all beauty professional licensees. We're not asking for anything more or anything less, just, hey, if you're a licensed California beauty professional, that you be treated equally. That's all we're asking. So that's something that I've considered, I've talked to folks, but we just haven't gotten to the point where a lawsuit has been filed.
I'm gonna pause that right there because I think what you just said, it reminds me of something that happened recently at a board meeting, which you are all welcome to attend. You can actually, if you're not able to be there in person, you can watch it happening live because all of them are webcast. But Kristy, I'm gonna call on you to explain what happened at the November meeting when the board took a vote about this topic, even though there was no bill to discuss. It was just the situation as we were going into the very last months of the year, and we knew that our exemption was going away. Remember the November meeting, we took that vote?
It took me an hour to find this room. So in November, we took a position to make a policy statement because we didn't have a bill. We'll take a position on the bill at our next board meeting, but we wanted to have a policy statement that said all of our licensees should be treated the same. So, so if we have that policy statement, that allows me to speak on support of any type of legislation that comes up, or doing what we can as a board, even though it's not our laws. So it's sort of out of our scope, but the board was very concerned that our one license type is being singled out. So we will be supporting any direction to make the change.
Kristy, can you explain how rare that is? Because I don't know that I've ever seen a vote on a policy statement.
I've been there for 19 and a half years, and I think that was my first time.
This is how important it is to the board. So for those of you who are concerned that no one's doing anything, believe me, there's been the groundwork laid in advance so that at the point that a bill were to get introduced, that we're all ready to mobilize. And that's why I'm so glad that you're all here today. So let me move on, because let's talk to Colin about, can you give us a little more background on Treetah himself and why you've explained who he represents, but I think it goes much deeper than that in terms of his involvement.
So, Assemblyman came to the U.S. as a refugee from Vietnam in the mid-90s, I think when he was like 19 or 20. Finished college here. He worked for the county social services agency for a little bit, doing like intake for government benefit programs, stuff like that. And he volunteered a lot with the community. At some point, that he got recruited to run for city council in Westminster, and that was kind of his first foray into politics. And then a few years after that, an opportunity opened up for him to become mayor of Westminster. So he ran and became the first Vietnamese mayor in the U.S. Of the city of Westminster, so that was pretty awesome. And then fast forward as mayor for a few years, the opportunity came up for him to run for this assembly seat, which includes Westminster, Fountain Valley, Stanton, Garden Grove, Los Alamitos, a little bit of Santa Ana. The district is something like 35–37% Vietnamese, so he ran for that and won, and just started his second term, doing a ton of bills last year, a ton of bills this year. But of everything, this is his passion and his policy priority. It's helping out the beauty industry because it's such an integral part of our district and our constituency makeup. So we knew this was coming up. We talked to Mike and we talked to Jamie a little bit late last year and kind of formulated this plan on how we can introduce a bill. And it's been introduced in prior iterations, but they died without a hearing or they died in committee. So we knew we had to do something different. We can't just put up the bill and expect everyone else to do the work, because we know what'll happen. So we're so grateful that with this bill, we introduced it just a week or two ago, so it's pretty new. It's AB 504. And the problem is now, legislators all up and down the state need to hear from manicurists on why this bill is important to them. If we just do the work and we introduce the bill and we talk to a couple of legislators, it's just gonna die. So we need everyone that's in the beauty industry that cares about manicurists, that has a manicurist license, to build a relationship with their legislator now so that they can properly advocate for the bill before it comes up for a committee vote. To make sure it gets a vote, it's the most important thing. The judges just die without votes. That's actually really sad. It happens more than you would think. But we want to make sure that it gets to a committee hearing and it's at a place where we can present our case to the Business and Professions Committee where we think it'll be at first. So do you want to fast forward to the next slide? I think that's the... Oh yeah, here it is. It's really simple. It's just that red line there at the bottom where it says, this paragraph shall become inoperative with respect to licensed manicurists. Just a red line through that. Nothing else changes. It's really simple. We have a fact sheet here about the bill if you want to read about it. And then I think on the next slide has the toolkit ready. Oh no.
We're not be there yet.
Not yet, I'm sorry.
Let me back up for just a moment. Because little known fact for those who may not be as old as I am and haven't been in the industry for as long, but back in the day, Trita was the managing editor of Viet Salon magazine. So you talk about someone who's not just representing a constituency, but who actually knows our industry. And Mike, you knew him from that role.
So in my manufacturing days, I knew Assemblyman Todd. Even I think before he was on the Westminster City Council when he was the editor of Viet Salon. So he is very invested in our industry. He knows the challenges. And you know, it's just awesome to have someone with that much knowledge and background about the industry really support us in moving forward here.
I think that might be the difference between previous efforts and this effort, because it does feel different. This definitely wasn't happening before. I don't think people even knew that there was a bill to remedy a situation because you didn't know there was a situation. You might not have known that manicurists were at risk of losing this right to do this work. So this is very simple right now. It doesn't need to be complicated. It doesn't need to be partisan. And I'm going to say that right now as someone who wants everyone involved. This is not about who you voted for or how you align yourself politically. This is about what's right for everyone, to give everyone a fair opportunity to earn a living in this industry. I know the buzzword this year is affordability. Well, how can you afford anything if you cannot choose how you work and what you charge and who you serve and what products you purchase and how many hours you work and on and on and on. And the issues that people would throw at us, like labor exploitation, wage theft, human trafficking, all of the things that people want to stamp on us as an industry, we need to acknowledge that those things exist, but they exist across a lot of industries, not just licensed manicurists, it's across a lot of different industries, and we don't get better by having our rights restricted. We get better by being able to exercise our rights and by having choices. And so that's where I come at it from. And I want to acknowledge something right now before we move forward. If you hadn't noticed, I'm a white woman. I'm white. And we're talking about a bill that if you look at the demographics, and you'll have to understand that the board is not allowed by law to collect demographic information on us. So in other words, if someone came to the Board of Barbering Cosmetology and said, Kristy Underwood, how many of the licensees in the state of California are Vietnamese American? She can't tell you that because they don't know. They don't know. So I am pleading to you as we move forward with this process is to understand your role in the industry and understand that this is not about pointing fingers at different constituencies, it's about working together because we owe a debt of gratitude to the Vietnamese American nail industry for allowing us to be in this position in the first place. And they are our colleagues, and we need to move forward as colleagues. So me as a white woman, I wish there were more people of color in this room right now. but we're going to reach them. We will reach them, we will link arms with them, and we will move forward. And I think Assemblyman Trita is like the perfect person to be sponsoring this bill. What we need, because we already have a co-author on the bill, and I will use this term now, another Republican has signed on to co-author in order to make this more broad and appealing to everyone in the legislature. We would desperately need, I would hope, some Democratic lawmakers to sign on as well.
Yeah, absolutely. We see this as a nonpartisan issue. The Board of Barbering and Cosmetology doesn't care if you're a Democrat or Republican. They care that you have a manicurist license, and that's what affects the industry wide. So, politically, we need support from Democrats, Republicans, people on extreme ends, moderates, everybody to co-sign this bill, to co-author it, and to eventually vote for it when it gets into the committee and then to the full assembly. And that's where you come in. Ma'am, do you have a question? I'm sorry.
The committee just mentioned it again. I'm curious when that might happen.
So we introduced the bill on, I think, February 10th, and it's not eligible to be heard in committee for at least 30 days. So I think the soonest that it could be heard would be like the week of March 10th, maybe a little bit after that. So it's coming up. Yeah, sorry.
I'm sorry, and it's really a question. How is it that an education can help support
Yeah, right. Great lead in, thank you. Next slide, please. Research the bill. There's going to be a QR code in a couple slides that you can scan. It's going to have a copy of the bill. It's going to have like a social media graphic that you can post and share with all your manicures, friends and colleagues about how you support this bill. Contact your state legislators. On that QR code, there's going to be a PDF document with how to find your state legislator, how to contact them, kind of a quick message on why this bill is important to your industry, but more importantly, why it's important to their district, and the economic considerations that go into the beauty industry and how it impacts their district. So if you can condense all that into 200 words, that's perfect. We're going to start a social media campaign on AB 504, so we'd love your help in promoting it that way. And then, of course, get your friends, families, and everyone in the beauty industry involved to contact their legislator too. So I would say initially, make an introductory phone call and say, hey, I'm in the beauty industry, this bill is really important to me. If you're able to, maybe we can set up a 15-minute meeting with a staff member that's working on this bill in the local office, or with the assembly member or senator, and I can have a few minutes to impress upon them the importance of why this bill needs to be passed. That would be a good way to do it. You can send an email. They all have the same contact form. It's standardized across the legislature. So you pick your legislator, write just a quick message and say, hey, I hope you can support this bill. Let me know what you need from me to get this moving. If you need any more information, stuff like that. And I think that's good. And then as it goes into the committee process, we'll talk about how, if anyone's local. Is anyone local in Sacramento? Okay, cool, great. Share your contact information, yeah. Does anyone want to take a bus to Sacramento? When it's in committee, it's really important that the committee members hear from nail industry practitioners. It'll have a moment or two to go up and say your name and why you support the bill, and what city you're from. And that's important too.
Can you emphasize enough how being brief and concise is probably the best way to get
absolutely. For what it's worth, I manage my legislator's inbox, and no joke, it's like 1,200 emails a day. Like, between my email, my legislator's email, it's just way too much to handle, and like 95% of it is just like crap. Like, you can't even imagine the stuff that comes through. It's total, I'll leave it. But it's important that you say, hey, I'm a constituent in your district. I rent a booth, I own a business, I've been working in the nail industry 15 years. This bill's been introduced by Assemblyman Trita. Please consider co-authoring and supporting it, because my nail salon employees my booth has 4, 5, 6, 7 different jobs that contribute to the economy locally in our district. And I think that's a really important message that you can hammer home. And it can be 5 or 6 sentences. In the toolkit, I have a sample letter that we'll talk about. you can send it to the committee when the time comes too, if you're a member of like an organization or something.
Thank you. Myra, you wanted to add something?
Yes, and Jamie and I will be working together also to launch a campaign through PBA. So we'll link all this information as well, and we'll also format it where you can put in your name and address, and it'll automatically send it to your member of the California Assembly for you, and have the talking points in there that's editable, so you can personalize it or not. If you're like, I want the representative, you can just send it that way. So we'll be working together to push that information out in the next week, so that that's accessible to you and forward that along.
Thank you. Yes, please.
Never underestimate your voice. And you might think like, I'm not gonna call my legislator, my senator, whatever. They listen, because they call me every day. I mean, they call me, I just had a call last week of, hey, I have a constituent whose license didn't get renewed, and I fixed it within 30 seconds. And like, I was like, oh, just call me. So that's how much they listen. So never underestimate if you think, oh, they're not gonna listen to me. They 100% listen. More than I thought when
I hope that gives you some encouragement that your efforts will not be in vain. You can say whatever you like, Kristy.
There will be people on the other side of this bill, and that's why we need you. There is people who think this should stay as it's currently written. And so that's why if you go to a bill hearing at the Capitol and only the other side shows up, what are the legislators that are sitting up there gonna think? There's just everybody's, no, leave it as is. So there is another side, and we have to, usually there's always another side, but there's definitely another side on this that we need to try to fight.
We're not an industry known for our advocacy, so don't assume that your state assembly person, your state senator knows anything about the industry at all, because it could be that their only affiliation is going to see their barber every 2 weeks, and they don't even understand what it is that you do or how you do it or why this is important to us. So you are there to educate them, because in respect, you are the expert, and you are more than entitled to advocate for yourself. There is no shame in saying, this impacts me financially, because you don't think that every other industry isn't screaming and yelling when their industry is impacted in this way. So thank you again for reinforcement. You can keep on saying whatever you need to say, don't apologize.
The show just opened, a couple hours ago, and already we've gotten questions at our booth as well, who's enforcing it? And I've seen some stuff on Facebook that have people who have said like, oh, I didn't change anything as of January 1, and I'm just doing the same thing. And that's great and gutsy. We don't enforce it, so we never will enforce it, and we don't even ask, right? But what if someone does, and they will? And so there's just, we have seen EDD go out and do a target of a group of nail salons or any salons. So we've seen it happen when this bill wasn't the case. So it's really a lot of risk for those people who are like, I'm just gonna wait and see if it's enforced. The thing is they could enforce it at any time, and then I would think that's a way bigger fine or issue than you would ever have with the court. So it is, they could do an inspection at any time.
Yeah, just to kind of follow up on what Kristy shared about the enforcement. In my practice, I haven't heard of any of my clients who've had an inspection by the Department of Labor or a complaint that was lodged with the Department of Labor in connection with the change in the law this year. But to make sure you understand how significant the impact could be, that if you are investigated by the Department of Labor or you are on the receiving end of a private lawsuit because you didn't classify your manicures correctly, for my clients, from the time I receive a lawsuit to the time we're fully done with either an administrative hearing or a court lawsuit, it could be in excess of $250,000. And that includes the attorney's fees as well as any wages. If you're the owner, wages that you may owe to the manicure. So just kind of be aware, it does have a significant impact when it is enforced. I just haven't heard of in a scenario or a situation where it's been enforced in the last 2 months.
And it can be retroactive to January 1st,
Yes.
regardless of when it gets done. And can we speak to the timeline, Colin? So we have a hearing. How soon, if this all went perfectly well, would this be enacted in the first place?
So you can safely assume that it probably takes a bill 8 or 9 or 10 months to get through the process. This year, everything will have to get through by the end of August, and most bills take effect the following January 1st. You can do it as an urgency bill where it take effect immediately. That requires like 2/3. And for right now, I don't want to focus on that. I want to make it as easy as possible for everyone to get this done by January 1st.
So the law that's in effect right now will be in effect until it changes. So even though we have this bill, that's just the beginning of this process.
Yeah, and we can expect that there could be amendments taken for concessions. We're sticking to the simplicity of the bill is kind of our goal, but it's possible that it'll get amended and we'll keep everyone posted on what that looks like, whether it's retroactively applied or not, or something else we're looking at.
Let me forward this slide. This is the toolkit that the Assemblyman's office has put together for you, which, thank you, Colin, again, for doing all of this work. So if you would please do, we'll be sharing this later through social media, but you have access to it first because you're here. That is the beauty of committing to being here in person.
Yeah, so that has it's going to open a Google Drive. It has a PDF of the bill. It's going to have social media graphic where you can change your profile picture or whatever. It has a copy of our press release, and then it has a sample letter, and then how to contact your legislator. But how to contact your legislator is kind of like two parts. There's the part that you can do individually. Everyone should be contacting their own legislator, but if you're a member of an organization or if you're affiliated with a club or something, you can forward your letter off to the committee, and then everyone will see it on their member iPad before the hearing. Like your letter will be there in a PDF. So that's really important if you're affiliated with the club, and there's a link to how to submit that in the portal. So it'd be great if you submit that like on the letterhead, and then you can edit the sample text in that letter to however you'd like it to make it personal for your situation. And get that uploaded. It has to be uploaded about a week before the committee hearing, so the sooner or better, but the later than probably 5 days before.
Did everyone get a chance to get this? Okay, I'm so excited because you've done so much of the work for us. Thank you, Colin. And then Mike and I want to keep you informed, so if you could please provide your email to us. We do not share it with anybody else. It's something that we hold near and dear to us, that you are giving us that privilege to connect with you. If you could please sign up, we will keep you informed so that you don't have to stay so focused, that we can alert you to a hearing date or some sort of call to action. So thank you again.
But start tomorrow. Call your legislator tomorrow. Email them tomorrow.
Tomorrow's Monday.
Yeah. No time like the present to get this going. So.
And Colin, if you were to call, how often can you call?
Great question. I have a lot of special folks that I talk to every day or every other day. And I would say that is too much. But if you want to space it out a week or every 2 weeks and say, hey, are there any updates on your member's position? I'd love to know if they're supporting this publicly or if they're interested in co-authoring it. I'd love to share it with all my friends. So you can call for updates every week or two and see. But this really has to be a grassroots effort from everyone up and down the state. It can't just be you and 3 of your friends. It really has to be an industry-wide push so that every legislator knows how impactful this is to the district.
Yeah, and when we speak of industry-wide, I have a manicuring license. But when there is a bill that impacts any licensee for the Board of Barbering and Cosmetology, I am there fighting, because I am hoping that when we need cosmetologists, barbers, and everyone else who's got a license to fight for my license type, that they will step up as well. So don't think that only your licensed manicurist friends can participate in this. Anyone in the beauty industry can participate. Anyone in your family, your friends, your clients can be calling. You should have a campaign set up at your salon to encourage your clients. You don't ask very much of your clients, really. They ask a lot of you. But if you came to them and said, you know what, I know we don't typically talk politics, but this isn't about politics, this is about my livelihood, I would be so honored if you would help me support this bill. And that's something I'm gonna ask my clients to do. All right. Oh, Kristy, you don't have to ask, just stand up and speak, please.
You might have mentioned this before I walked in, but there's a lot of misinformation out there as well. There's a lot of people, including maybe some past legislators, who are saying, oh no, you're fine, because that on the ABC test, there's that the business owner, says you have to, out of the scope of the business, right? And what they don't understand is that the board doesn't issue nail salon licenses. If we did, and you were a single nail salon license, and we issued a license to the nail salon, but you're a manicurist working in a hair salon, because we license hair salons, we'd be having a different discussion. But that's not how it works. We issue establishment licenses. We have no idea what services are being done in any salon, because you can do all services in every salon, right? So that's the performance of work outside the usual course. And I've seen some past work people saying, oh no, it's outside of the scope. It's not outside of the scope. It's 100% not outside of the scope, because we only issue an establishment license. So whether that establishment owner is Joe Schmo and never been in part of that industry, they could be a manicurist, they could be it doesn't matter. We issue it all, the license is all the same. And that's what, if they had only asked us back 5 years ago or whatever it was, we did try to help. So there's a lot of misinformation out there as well. I've also personally been told that people have called the Labor Commissioner's office and have been told on the phone or even in email like me that no, you're fine. And it happens in our board all the time. We say the wrong things, and in that case, they were saying the wrong things. And again, it's government, and I can say that because I am part of it. We don't talk to each other very well. The Labor Commissioner's office is a different office than ours, and we've tried, and we've really tried hard. And it's just you've got to be careful, because the person you get on the phone or the person sending you an email might just be getting that phone call done or getting that email out and not really know the true answer.
You have just saved a whole bunch of trips to your booth. Because we did talk about that just before you came in.
Sorry.
No, don't apologize. The point is you need to hear it from the source. We reinforce that over and over again in our podcast, is that you can listen to us talk. This is our opinion. We're basing it on our resources. But look at all the resources that you have access to. You have Myra, you have Kristy Underwood, you have Colin Edwards here. So you have access to people other people haven't. You can figure out who these people are or who to talk to. You have that access now, and you can get the real thing.
Let me just make a caveat on the access. The source that you're looking up, make sure it's a credible source. I am not a believer in Facebook being my source of information when it comes to regulatory, law issues. Contact someone who's reputable, who's qualified to do that. And if you're hearing something that sounds just a little off, question it, and then contact another reputable source. Because the last thing you want to do is follow Facebook information and then be on the receiving end of a lawsuit, and you want to tell the government attorney or private attorney, well, Facebook said it was okay. When you come to me and say, Michael, you defend me, I said, what do you want me to do? You said Facebook was okay, it's not okay.
What about ChatGPT, Mike?
That's another one. Be careful.
And I would like to position this not so much as a fight for our rights as restoring our rights, because we had them. And through just being overlooked and being apathetic or whatever it was, we could dissect how this happened, and the fact that, again, the legislature doesn't necessarily understand our industry very well. There's not a lot of communication between the agencies. If only they had talked to Kristy Underwood or had come to the board or whatever. We could have avoided all of this, we got that. But we have to start opening the lines of communication, and we don't do that by pointing fingers, putting people on blast, I'll use that word, blast. It's not about that. This should be a positive thing. You want legislators to feel good about working with you. You're not working against them, you're trying to have them work for you. Let's take questions. Okay.
I'm just curious, like, on their end, what their goal was with this legislation.
I do, because I actually had conversations with the author of AB 5 on the back end, because I like to do things quietly, give people space to maybe grow in their positions, right? Not do these things privately. So I think they thought they were protecting manicurists. That this was seen as a solution to problems that have been amplified. And when people don't understand what they're doing because they haven't had the opportunity to invest as much time as we would have hoped before making a decision, then this is the kind of decision we're left with. And I take responsibility for that. And we should, as an industry, take responsibility for not being more engaged all the time, so that they do understand. Or if they don't understand, they know to contact us before making a huge decision that's going to impact us. So I think I don't think that they weren't persecuting us on purpose. It's that they thought they were doing the right thing.
And if I could just say one thing on that, could you go back to the 2770 slide, even the one where Colin redlined that one? So if you look at the current labor code, is 2778, what you see on here, where that red line is, that's actually law right now. They're proposing to strike through that. But from my perspective, if a licensed manicurist has performed their services in compliance with subsets 1 through 5, right, they would still be considered a properly classified independent contractor, whatever term you want to use. If they're not following 1 through 5, then automatically they didn't even have the benefit of being independent contractors, right? They would have been by default, and the other option is an employee. So in my discussions with attorneys, legislators, by changing law that you're now protecting them, no, it's just enforcing the current laws that are on the books. Because if any of these subsets 1 through 5 has not been met, you're not an independent contractor in the first place, right? Nothing has changed, but by adding sub 6 there, that makes a significant change for only one class of licensee, the manicurists, right? So, if you ever have a discussion, there is no change in the law. Had they just followed 1 through 5, you would have been independent.
On that note, I was contacted by someone recently who was explaining their situation to me and was upset that things had changed, only to find out that that person and that business had been misclassifying its employees this entire time. They weren't even following the law. So in certain respects, this was probably a good thing because they had been misclassified as independent contractors up to that point. So as we move forward, that's why our entire reason for being is compliance. And if you don't think the laws serve you, you go through the process. Defiance does not help, because why have the rules at all if you're not going to follow them? So that's why we're always emphasizing compliance, and when there's something that's not right, then we work through the process. And this is our process. Other questions? Yes?
How do these changes apply to things like agencies, like Hollywood, Barbering, or even third-party platforms like
I can answer that question. My sense is that those businesses were not compliant in the first place because they were collecting the money from the clients and not you. So they were already out of compliance. No, it's because they're not collecting the money. They're collecting the money on your behalf and then giving you.
Shouldn't have that gray area
but they're not
conditions.
the point is that in that example that she's giving, those people are being classified by their employer as independent contractors, but they're not.
And that's where that whole commission thing.
No, it's actually separate from commission, because it says,
It's because as an independent contractor, you should be handling your own money and taking your own payment. And because that third party overseer, the person booking things and then processing the payment, now that breaks that. Now you have a relationship with that person and you shouldn't. So now legally you're not a, but I know what you're saying about commission.
The same thing,
Yeah.
because commission, they should be paying us directly, and we should be paying commission to the donors.
No, it actually shouldn't be done that way. And there was a law change through AB 1513. And SB 490, I'll just touch on this for 1 second, because this is a perfect example of how we had to go back in and try to fix something, and the fix, everyone was still angry about it. So you have 3 ways to pay. You can pay straight hourly, which is straight hourly as an employer, or you can pay piece rate, which is at least minimum wage for every hour on the clock, plus a financial incentive for whatever you do, hair, nails, or anything. And then you have commission, and this is where everything got super confused, because we got swept up as an industry into the result of AB 1513 and piece rate versus commission, and the state of California said, oh no, you're not commission. There's no such thing as the beauty industry being commissioned. You cannot pay that way. Just like I say, you can't do it like that. Okay? So then we had to go back in and introduce what was SB 490, saying we have to have commission. Everyone is used to paying that way. When you say, I'm going to pay piece rate, you're like, what? You know, like, I don't understand what that is, right? So it's in the language, it's in the way that the beauty industry works and is paid. This is the whole point that they're trying to make about establishing that relationship and you becoming the resource for your elected official, because they have no idea what the industry's like or how to get paid. That's why Mike essentially is a unicorn, right? Because he is an attorney, but also has beauty industry clients. There's not a lot of Mikes that have the legal background as a professional that understand how you get paid and how it works. And it's generational too. And let me tell you, it's nowhere else except for California, which is another thing. So with the commission, we had to go back in and say, please, let us pay commission, because this is how we work, this is how we do things, this is how people are used to being paid. And they said, okay, these are concessions. We'll let you have commission, but the base hourly rate of pay to get commission has to be 2 times the minimum wage, and that's before the commission is paid. So we did a lot of back and forth, went to our board, our advisory councils, all of that, and they said, we have to have it back on the books, or else people are gonna get sued. So we said, okay, we agree, that SB 490 passed. Now you can do commission, but it has the concession attached to it. Why? Because other industries that do commission have that same rule. And they were comparing it to like auto mechanics at a dealership. If you go back to the dealership to get your car serviced, how it's broken up and what their minimum wage is set, that's what they compared it to. So, but why were they saying at least 2 times the minimum wage? It goes back to protecting. We have to protect the licensed professional from getting scammed out of their money. And that's the way they were looking at it. So the concession was from a good place saying, you have to make sure that person has a living wage. You have to pay them for every hour they are on the clock, regardless if they're paid for or they're providing a service. And so that's how that law changed. So the commission, although in your mind it probably connects to an independent contractor, it has nothing to do with that. Because if you're an independent contractor, the person renting your space should not be paying you. The client's paying you. Sorry, I'm yelling at you.
This is why everybody's
because it's caused, I mean, you know, California is my special state, special dollars. You guys are my special state. Because things happen here. Because we do all 50 states, but no one else has a commission. No one else has an SB 490.
On commission, and he only paid me commission of the services that I rendered. And I told him, you can't do that. You can't have me sit here all day and just pay me off of one service.
And it doesn't have to be what SB 490 is in California, but under federal law, they cannot. That's another thing. You need to know what you're supposed to be paid before you work. It can't be a, at the end of the week, let's average this out. And if you make more It's nothing. It doesn't match piece rate, hourly, or commission. It's like some made up way. And they're like, well, I'm renting space, and they'll never get out from renting space if this is how they're getting paid, because they won't make enough. Oh, there's just so much wrong. So it's not that the Assembly's like trying to attack the industry. I genuinely think people are like, you have to be fair, you have to pay right, you have to follow the laws. So we're gonna introduce things that kind of force and make that happen. But because of that, with AB 15 and with this right here, we got swept up in a way that was not intended. Because the legislation is never written for the industry. It's the result of the court cases that Mike talked about, and it swept up everyone, despite the structure of how you're used to being paid.
So,
Thank you. Let me hold off, right, because we're at 11 o'clock right now. There's gonna be another class in here, and I wanna be fair to everyone. You know how to get a hold of us, but I have an ask for you right now. Again, I told you at the beginning, there are no glitter in this class, no rhinestones. Premier Anaheim took a risk by even holding this class. If you think this class was worthwhile, I want you, when you leave here today, to tag the show and post about this class. Because we need to have these kinds of classes at every show. We need to hear from Myra. We need to hear from labor attorneys. We need to hear from people who can tell you how you're supposed to compensate people, how to stay compliant. So I want you to praise them for giving us this opportunity. And I am thrilled, absolutely thrilled that so many of you were able to be here today. I would have been happy if 4 of you showed up. I mean, maybe just the first 4, but it happens.
Every show or conference that we're at, we at least have one of these classes, and I mean, I've put chairs in a circle and been like, let's talk, 3 of us together, and nobody really will come.
Yeah. So please, and that's an ask from me. We don't get these classes unless you guys support them. But if you just show up and walk away and don't let the show know, because no one stopped by to do a head count or to find out. They probably think this class is, yeah. So please do that for us. We'll take just a few more questions, but we're gonna move. If we want to have a conversation in the hallway, we certainly can, but we need to clear the room to respect the next educator who is coming in. That's what I find.
her question, because I'm a little bit confused.
What's that?
So somebody who works on set or is booked through an agent, this is going to affect them also? They're gonna have to be employees of the agency now? Is that what I heard?
You have to be.
Because they're not looking for this.
Yeah, I just wanted to be clear because I didn't follow along fast enough to catch if that's what you said.